Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. Today, we're going to be talking about the most recent Ripple v SEC lawsuit news. If you are an XRP holder, you definitely want to watch this, or if you're looking for a good opportunity or want to just kind of figure out what's going on with XRP, make sure you watch this video. But for right now, make sure you press the like button, and of course, make sure you subscribe and have the notification bell on. My question of today is, if you had to pick one crypto that you'd have to hold for the next 10 years without the possibility of selling, which crypto would it be? Let me know in the comment section down below. So first of all, XRP community, SEC v Ripple. Last night, the SEC filed under seal a letter motion for a Rule 37.2 conference, which means there's a discovery dispute. So this basically means, hey, SEC is saying there's something we don't agree with. We want to kind of fight this out. No corresponding public or redacted document has been filed, so we don't really know exactly what the dispute is all about. Usually we see a redacted version of the letter motion, but nothing has been filed yet. So we don't know exactly where the dispute lies, but they want to take it further. They want to, get a conference going. Ripple filed a motion for extension of time to respond to the SEC's motion. So basically this motion just now. In that motion, Ripple said that the parties will address any sealing issues in the letter motion in their subsequent submission, so I don't think we will see anything until the sealing issue is decided. We are also still waiting for a decision on the use of foreign MOUs, and don't forget the conference this Friday. The court has not yet indicated how many callers will be accommodated on the public line. So I'm definitely going to see what we can do. I will be live streaming tomorrow. Obviously, we'll discuss everything that's going on, but I'm not sure if we're going to be able to call in. Going to try my best, obviously. Otherwise, we're going to have to go through some sneaky measures to get ourselves some footage. But I'm going to get you guys everything. Do not worry about it. I got you, all right? I'll make sure we have at least something. So make sure you stop by tomorrow because the Ripple hearing is going to be. I'll make another video later tonight explaining exactly what is supposedly going to go down. Here's a little letter. It's not that interesting. We write on behalf of defendant Ripple Labs, pursuant to Part IG or 1G of the 1D of the court's individual practices, and with the consent of the SEC, to request that the deadline for Ripple's response to the SEC, May 18, 2021, letter motion be extended 2 business days from Friday, May 21st to Tuesday, May 25th. Ordinarily, Ripple's response would be due on Friday, May 21st. Ripple respectfully requests another 2 days. Once more, in light of the Discovery Conference being held on May 21st, to fully respond to the letter motion. This is Ripple's first request for extension of time. Ripple sought the SEC's consent by email on May 19th and received it later that day. Both parties will address any sealing issues raised by the letter motion in their subsequent submissions. All right, let's quickly see what else is in here. It's just a kind of an end of the letter. Now, somebody says, thanks, James, for all your updates. Next time, okay, never mind. That's something else. All right, let's see. Then 2. So there's 3 things which came out today, as I just said. If you're watching this far, make sure you press the like button. I try to get you guys the best content. In this specific case, I didn't get it as soon as possible. Why? Because I knew that more stuff was going to be coming out, and I was kind of waiting for another little document here. We didn't get it. I'll talk to you guys in just a second about what I mean. Breaking. Decision on MOUs. SEC can continue to use MOU process, but the SEC is ordered to produce all documents obtained in response to their requests. In addition, to improve transparency in the process, the SEC is ordered to produce copies of all previously served requests within 14 days and produce any subsequent requests within 14 days of their service. To the extent the SEC believes it has proper claim of privilege, it must simultaneously produce a privilege log. Whew, sheesh. So I personally think this is not really a big deal. People talked about this like this is Ripple's first loss. I'm not exactly sure why that would be the case, honestly, because the MOUs, Ripple, I guess, quote unquote, losing to the SEC or the SEC getting to use them is really not a big deal, because think about it from this perspective. The only thing Ripple's been saying is, well, we don't want this to happen because you're partially scaring our I'm not going to call it clients, but our partners, which is true, and you're also just using something which we can't. However, to stop that usage, all it would take is for the SEC to go through the appropriate measures, which basically would mean now they cannot, quote unquote, force it anymore, but they're going to get those documents anyway. So they're going to have to go, delete basically everything they've gotten and do it the legitimate way, which would take time and would just unnecessarily extend this lawsuit. In the end, I don't know exactly what purpose it would have to deny it, except for the fact that you just want to deny it, or you want to make sure that they cannot do anything, over you. But the judge, I think, also ruled here reasonably, thinking, you know what, the SEC has documents here which they have already got now, they will most likely still get anyway. All it would take now is, or all they would do now is just kind of make things a little bit longer, since they would just have to throw the documents out and then re-request it, but in the normal way, they would most likely still get it, you know? So I also understand that there's definitely some lenience, or there's some room for discussion as to what is smart and what is good. I can understand both sides. Ripple's perspective as well. Let's make it fair. Let's make it a level playing field, and let's make it so that the SEC has to try get those documents, and that, you know, since the SEC is the only entity which can request this type of stuff, let's not make it possible. Because we couldn't do that. It's not a level playing field in Discovery. We should have the same amount of options. Another point to add here is that the SEC could have requested all of this, but they should have done that before Discovery, because right now you should have a level playing field. You should be able to get the same type of stuff if you want to. And Ripple right now would not be able to get the same documents, which is one of their requests, which is that the SEC make everything they get basically available to Ripple as well, and to the judge to see everything. And one of Ripple's comments as well before was, well, we don't mind you too much getting all that, but we wanted to go through the court, and that's also what the court has now decided, that everything has to be, you know, put up, and they have to, I guess, show a privilege log, which basically means why those things were privileged. I mean, I think at least. Somebody says, very simple, in my opinion. The SEC can't win. XRP is being used today as a utility token, and Ripple has plenty of ODL customers to prove it. And it has happened exactly 3 years after the last bull run. Someone powerful is buying time. I'm not exactly sure, guys. I personally also think the SEC cannot win. All we're doing here is just delaying the inevitable, or kind of prolonging a war, which, again, there's no real good end to, as the SEC will not win on every ground. They might win and give Ripple a fine on that perspective, but they will not win the entire lawsuit. There's 0% chance, in my own personal opinion. Once more, guys, it's just my opinion. It's not an official legal opinion, not a financial advisor. I don't know in the end of things, right? But I think SEC v. Ripple. SEC files its response to Ripple regarding the SEC motion to compel the turnover of documents regarding legal advice Ripple received about whether sales or offers of XRP were securities. And again, this is some topic I'm going to be discussing later today, talking to you guys exactly what I think is going to happen tomorrow. Once more, I will definitely be streaming. I might even stream a little bit later today. Who knows? We'll see. But here, the SEC has basically refiled another response to Ripple, which just filed a document talking about the motion to compel. It's basically the SEC came up and said, hey, we want to get all the documents regarding what you got in terms of advice regarding XRP. We want those documents. Whenever you said it, you know, you got given financial advice, we want to see those. Ripple said, you know, you don't have to see them because it's privileged, since, well, it's basically an attorney-client privilege where we don't have to show you that type of stuff. And the SEC says, well, it's not privileged because there was a third party involved. You showed those documents to a third party. And Ripple replies saying, no, that works a little bit differently. And now the SEC has responded again. And the reason this is all going so fast, I've already told you guys before, but the reason this is all going right now is because there's a hearing tomorrow about this specific subject. And I already said there's a good chance that this hearing is going to be quote unquote negative, because, I mean, if Ripple, as it currently stands, right, if Ripple really got advice and gave it then to their clients partially, then the privilege thing is gone. And so, like Jeremy Hogan, the attorney, said, you're going to fight, you're going to try your best, but, you know, it's basically an uphill battle from this point on forward. Is it a really bad thing for XRP? No. I mean, people are valuing it right now as if the world has crashed and things are really doing bad or anything like that. The price went down quite significantly. I don't think it's that important, to be honest with you. I don't think it's really that significant, that interesting. This huge sell-off obviously was because of Bitcoin, but the momentum afterwards, it wasn't, I guess, up par with some of the other coins, mostly because of the negativity. And sometimes you think about the timing, man. XRP was doing so beautifully, then boom, a Bitcoin crash comes in, taking XRP down to the ground. And once it's already being, you know, feared, people are already scared and whatnot, boom, there's another jab in the freaking face with these two little things coming out. An SEC response is not necessarily negative. They're just saying Ripple misstates applicable fairness doctrine principles. They also said here, Ripple's fair notice defense is a good faith defense resulting in waiver. And I think that was the last one. Let's quickly check it out. Yeah, that was the last one. They put up two things. There's definitely debatable facts in here. I think the judge is going to also talk a lot about this fair notice defense. I hope at least, because Ripple says it's a good defense. The SEC should have given fair notice. And so anyway, they couldn't have known. Ripple should have never known. The SEC likes to debate about that one, about the fair notice. And the misstating the applicable fairness doctrine principle about the fair use and all of that, I believe. I don't know. The SEC's motion rests on one principal argument, the fairness doctrine. Requires that Ripple produce the legal advice it sought or received as to whether it offers or sales of XRP were or would be subject to the federal security laws, because Ripple has put such advice at issue in this litigation. Motion at 3 to 5 at issue waiver applies because even though Ripple does not attempt to make use of legal advice, Ripple's fair notice defense asserts a factual claim, the truth of which can only be assessed by examination of a privileged communication. So once more, here what they're basically saying is, even though the Ripple side doesn't actually talk about this specific advice at all, the SEC says we need this advice to kind of see whether or not their defense of fair notice is actually useful. And to kind of go deeper into that, fair notice, what Ripple basically said is, well, two-parted. One, the SEC should have given them fair notice, but also the SEC should have given all clients working with Ripple fair notice that, something was coming or that they were really, negative on it. And the SEC is basically trying to say the fair notice here wasn't necessary. First of all, because it's not necessary by law. That's kind of what the SEC is saying. But also because you knew, right? You knew that this was coming up already. And if you thought about it being a security before, then we don't need to give you fair notice, basically, because, well, you knew about it already. So what would fair notice have helped for? And all that type of stuff. I think exactly that's what their point is here. They want to see that Ripple thought about it being a security before or asked about whether or not it was a security before. So the SEC has some extra legs to stand on. And as long as the judge doesn't budge, this could be really huge for Ripple. On the other end, if they didn't say anything crazy in these documents, which is also a really good possibility, then also no worry. It is only if they said something crazy that things might get scary. But whatever, you will see. For right now, this is what it is, and let's just wait it out. Let's just wait it out. Let's see. We got a big thing tomorrow coming up, and I'm not really that negative about it, guys. But it is some big news, so make sure you understand that. Here it says, a lot of articles were written this way, judge delivers blow to Ripple over foreign discovery. I mean, it's just one of Ripple's first losses, quote unquote, in this lawsuit, but it's really, luckily, not the biggest one. I think the use of foreign MOUs is negative because Ripple wanted to kind of, get against it. But in the end, after thinking for a little while here, it's not really that big a deal. Let's quickly actually see if Jeremy Hogan said something on Twitter by now. Maybe he replied to some of these documents before, or John Deaton. I think John Deaton said a lot of things, but let's quickly check if Jeremy Hogan. Let's see if he quickly said something. Make sure you follow me on Twitter, by the way, guys. TheDustyBC. You can see it already down there. Make sure you follow me. So he only replied to the first part of things. He says, my initial impression after hearing was correct. The judge rules in the SEC's favor on the MOU issue. I believe this is the wrong ruling and shows the judge does not understand what is truly going on with those requests. Also, why did page 2 order take 3 weeks to draft? Yes, there is a disclosure requirement, but the real reason the SEC uses the MOU is to intimidate and ruin business relationships between defendants and the subject of the request. I think so too. So basically they're trying to mess Ripple up a little bit because, well, think about it. If you're working with a company, right, as an example, and all of a sudden, a freaking U.S. government shows you a letter saying, hey, hand me these motherfreaking documents right motherfreaking now. You're like, ooh. Might not want to work with you anymore, my guy. You're in a lot of trouble. I don't like you. And that's, again, what Jeremy's saying is here as well. It is a bully tactic we need judges to stop, and it irritates me greatly. I need a drink. Damn. All right, having said that, I'm going to go back to the pool, I think, man. This is making me hot right now in a negative way. I think it's kind of BS, but then in the end, I don't think it's really a bad deal. Do I think it's bullying? Do I think it's stupid? Of course. But as the judge basically said it, I listened to the previous discussion, right? I guess let's conclude it here. It was a way off against basically fairness and speed. That's all you can say. Because the SEC has the required, capacity. They are allowed to do this. But the question is it fair? And should you allow this? Even though technically they are allowed. The judge apparently thought, yes, sure, why not? She prefers speed over fairness. Because in the end, fairness meant they just have to go through the normal process of getting documents and, don't intimidate those guys too much. The SEC's argument was we will intimidate them anyway if they were intimidated by this. I disagree. In this case here, once more, it was not a question, is an obligation, what they put on them, but whatever. Guys, that was it for today's video. Hopefully you all enjoyed it. If you did, make sure you press the like button and subscribe. And there's more videos coming out every single day, so make sure you press the freaking subscribe button and check out Bybit. A link is down below. You can do $130,000 worth of trades for free by depositing and whatnot, so check it out. The link is down below to Bybit. I'm using that myself. There's a freaking $2,600 bonus. It's crazy.